Hello and welcome to episode number 2 of Fire Away, an online question and answer show focusing on the employment law issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator, founder of Rudner Law, and I'm your host for this show. Just so you know, Fire Away is available, past episodes of Fire Away are available online on our website, on our YouTube channel, and on our Facebook page. And of course, you're watching this live on one of several platforms available to you. Last month, the first episode, I mentioned that we had a number of exciting topics and guests lined up. Today, I'm joined by Ed Prutschi, who's a well-known criminal lawyer in Canada, as well as media commentator. Interestingly, last month, I had Andrew Feldstein, a family lawyer, join me, and we talked quite a bit about the Me Too movement and sexual harassment in the workplace, how it impacts family law and employment law. This month, I've got Ed Prutschi joining me, and we're going to talk about the very same issue, but from a very different angle. So, and of course, I should mention that we're always happy to answer your questions. So if you have any questions, you can post them on Facebook or you can tweet them to @RudnerLaw. So first of all, Ed, thank you very much for joining me on our second episode.
Hey, it's really a pleasure to be here, Stuart. Thanks for the invitation.
I'm looking forward to the discussion. As I said, we're going to focus on the Me Too movement and how it impacts both of our practices and the overlap between them. So as a starting point, I can tell you that as an employment lawyer, ever since the Gaithersburg scandal, which is now a few years old, the number of harassment complaints that we dealt with just shot up. We had to deal with the impact of the criminal trial and what happened to the complainants in that context. And then we had the Harvey Weinstein scandal last fall, which led to the Me Too movement and a tremendous shift in terms of how workplace sexual harassment is dealt with. And the harassment complaints come in left and right, and we are dealing with them constantly. What I was curious about is how the whole Me Too movement has impacted your practice.
Yeah, it doesn't surprise me that you've seen such a dramatic shift just in the last little while. Now, I mean, for me, it wasn't actually Gaithersburg that sparked it, although I would have expected that was the case. In the Gaithersburg trial, you know, I was getting all of those classic questions directed at criminal lawyers, sort of, how do you sleep with yourself at night? How can you do these kinds of things? Why would you ever represent a person like that? And how could he possibly have been found not guilty? And so there was that conversation and discussion. Then the Weinstein issue kind of hit the fan, and everybody was talking about Hollywood in particular. The hashtag #MeToo was, of course, burning its way through social media everywhere and anywhere. And yet still, it didn't quite resonate, I think, at least in my practice in Canada, until even a little bit more recently, what I call the Soul Pepper 4. And maybe that's a little less famous or infamous to sort of international viewers. But if you were certainly living in the greater Toronto area, across Ontario, and really around Canada, you probably saw this issue where the beloved director of a well-known, high-profile theater company here just went from top of the world to bottom of the trash heap almost overnight. And it was this decision by the 4 women who came forward and said, you know what, we're not going the criminal route. We saw what happened to Gaithersburg. We saw the kinds of things that are happening in Weinstein. That's not for us. We're making new trails, and we're going litigation-wise.
That's actually a great segue to another thing I wanted to ask you about, which is I think we've heard a lot of people say that, particularly after Gaithersburg, they have no interest in filing a criminal complaint, and there's really nothing that they can gain from doing so. So in my practice, of course, I see complaints being brought to HR or to the owner, or individuals are going straight to their lawyer and either threatening a civil suit or bringing a civil suit. So in that context, is there a role that you as a criminal lawyer can play?
Yeah, so interestingly, I mean, obviously as a criminal lawyer, the first concern is, oh no, if everybody's dumping from the criminal justice system, you know, what am I going to do for a living kind of thing? The reality is that hasn't been a problem. In fact, quite the opposite. I get more and more clients coming in, calling in, emailing, texting, and just arranging for consultations precisely because they're on one of 2 sides of this debate. Somebody has made an allegation against them. Sometimes it's not yet public, but they know that it's coming, or vice versa, that it's a person who's a complainant and saying, I've got a problem at my workplace. I've got a problem with a specific individual. I want you to help me make the decision. So the very first thing they want to know is, how do I make that decision? Do I go the criminal route, or do I say that's not for me? And do I try to find a civil claim? Do I try to go to an employment lawyer? How can you sort of help me? And so I've become a little bit more of a quarterback, and the team has expanded, working with lawyers like yourself and saying, you know what, there are options available to you. Let's talk about the pros and cons, because it's not a simple decision. There are benefits and costs, I think, to both routes that you can travel.
Yeah, and that's interesting. Obviously, as you said, that's a chance where you and I can work together on a case, even if there is no criminal prosecution. But it's interesting that you're, of course, well known as a criminal defense lawyer, but you're also being consulted by victims or at least alleged complainants. And thanks, Rob. I see that we have a question here, so I guess I can answer this one fairly quickly. The question is, do you represent employees or employers? From my perspective, Rudner Law addresses or represents both. We work with individuals in a number of contexts. Probably the most common is termination, but also we review contract offers. And over the last couple of years, we are working with a lot of people who have either been harassed and don't know how to protect themselves, or accused of harassment, like Ed was just saying, and need to defend themselves. And on the other side of the coin, we work with employers who have received complaints of harassment or have become aware of potential harassment and need to be advised on how to handle them. And I'm going to talk about that a bit more later, but we work on both sides, and Ed, it sounds like you are as well.
Yeah, absolutely. I think that takes people by surprise because, of course, I call myself a criminal defense lawyer. Our firm is criminallawcanada.com, and everybody's thinking, okay, we know what side of the fence you're on. And the reality is that's not true. I mean, like many lawyers, we will represent anybody who has a legal problem, and that can mean the complainant, the victim in a case. It can mean the defendant in a case, and as you discussed, that can also mean representing a company either because it's on the defensive side, where somebody has made a claim and said, look, your employment environment is toxic, and there may be criminal charges coming against your CEO, for example, or some other senior employee there, or the reverse, where it's an employer actually stepping up and saying, you know what, we want to take the appropriate action. We want to know, what should we do? Do we go to the police with a claim like this? And if we do, how do we help the police prosecute that? What is our responsibility?
Yeah, I think that's interesting. A lot of people would not realize that you act for both or can act on both sides. And you mentioned people coming to you sometimes proactively. So this is something else that I've seen a few times now. A lot of the scandals that we have seen don't refer to current issues, but historical issues. And a lot of the high-profile cases in Hollywood are not necessarily ongoing sexual harassment, but sexual harassment or even assault that dates back years, if not decades. And I've had people come to us and say, I did something I'm not proud of 10, 15, 20 years ago and thought it was water under the bridge. Now with everything that's happening in Me Too, I'm terrified that the person involved is going to come forward and I'm either going to lose my job or be prosecuted criminally or lose my marriage or all of the above. Have you had people coming to you of concern they may be prosecuted for something they did a long time ago?
Yeah, so speaking criminally, and I think this takes some people by surprise because it's not the example in the United States, there are no limitations periods for criminal offenses in Canada. I mean, there are for what are minor criminal offenses called summary conviction. And in the case of assault and even sexual assault, the Crown could choose to proceed by summary conviction, which would give you this solid limitation period and say after 6 months they can no longer prosecute. But the reality is the vast majority of cases in the criminal code, including the kinds that would be covered by sort of hashtag Me Too behavior, can be proceeded with by a more serious route known as indictment, meaning that you're never safe if you're facing an allegation like that. It can rise up 5, 10, 15, 20 years after the fact. Now, when complainants come in and ask me and they're proactive, that's how you started the question, somebody coming in and saying, hey, there's nothing in the weeds yet, but I'm worried about it. Whether you're on the defense side or on the complainant side in that circumstance, that's a very smart thing to do. When clients wait, it actually gets a lot harder for us to fix the problem later on. If you're a complainant, even though the law says it's not supposed to matter, the reality is memories fade, documentary evidence disappears, corroborative evidence disappears, and people start to scratch their heads if you're going in front of a jury or even a judge and asking the question, why wait so long if this was such a big deal at the time? So timeliness is very valuable in your arsenal if you're a complainant. And if you're on the defense side, you get worried about it because ultimately, even though you've got proof beyond a reasonable doubt on your side and you've got the presumption of innocence on your side, boy, it sure gets hard to respond to allegations that may be 5, 10, 15 years in the past. And, you've long forgotten about them. The people who you think might have been on your side and could have corroborated your side of the story are also long gone and past.
Yeah, I think that's a great point. And it kind of reminds me of advice that we often give. Again, in the employment context, sometimes there are consensual relationships that go on for weeks or months or years. But I've seen this situation where one party decides to end it, the other party won't accept it. And in several cases, people have threatened to allege that it was harassment and non-consensual the whole time. And then I've had people come to me and say, how do I defend myself? I was in a romantic relationship with someone for years. Now they're threatening to say that I forced them into it. And so we'll often try to work with them to give them advice as to how they can gather documentation. And documentation can be text messages, email messages. I mean, in one case, notes, that were accompanying flowers that were delivered, anything they can. And thanks, Rob. I see that we have another question, which I will get to in a second. And it looks like it relates to a question I wanted to address anyways. But we've often coached people on how to gather evidence to prove that a relationship was consensual, which is often counterintuitive. From your perspective, if someone comes to you and proactively says, I'm worried I might have allegations made or a prosecution commenced against me, what do you tell them?
Well, it's so interesting because it's the flip side of that hashtag #MeToo coin, right? Some people complain and say, my God, we're living in a social media world where anybody can attack anyone on Twitter, on Facebook, on Snapchat, on any of these things. But the flip side of that is that there's almost always this incredibly long trail strewn with documentary evidence that you kind of forget about, because now we live in such a world where everybody's tweeting, everybody's Snapchatting, everybody's posting something on Facebook, everybody's texting. They're not making phone calls, which much more commonly people are not recording, right? It's not, you've got to be a pretty paranoid individual to sit there and record every voicemail or every telephone call that comes in. But it's automatic when it comes to text messages. So we tell clients when they come in, regardless of which side you're on, complainant or defense, look, if you want to bolster your claim, now's the time to preserve that evidence. Let's go back through those text messages. Let's go back through your social media feed and start snapping sort of digital imagery of that, because once somebody blocks you, once somebody deletes you, we may not be able to get access to that anymore. And Snapchat in particular, I mean, I'm an older guy in my 40s. My kids use Snapchat. I've had to learn about Snapchat because it's effectively designed to self-destruct. So people say, well, what do I do about Snapchat? I had a client in my office literally yesterday where we had major concerns about stuff that was going back and forth on Snapchat. And what we did is actually record live on my phone Snapchats that he was opening from this same woman who we had issues with, because we knew once we opened them, they were going to disappear. We didn't want to click the screenshot button because then she would know that we had them. But now we've got that documentary evidence preserved independently in a different way. And when and if stuff hits the fan, as we think it might in this case, we've got it. And she's under the mistaken perception, I think, that it's gone because she used Snapchat. Well, that's not true.
That's a great suggestion, because I have this all the time where we're dealing with an investigation of alleged harassment, and sometimes it's text messages and they may have been deleted, they got a new phone, whatever the case may be. And there's so many misconceptions out there. Some people assume that you can never get them back. It used to be BlackBerry Messenger, and I know you were a BlackBerry fan. I'm not sure if you still are.
That was the vehicle of choice for anybody who was either a troublemaker or a lawyer, and I guess some people would say that's people.
Yeah, there might be some overlap in those two groups.
Yeah, your PM was not going to be retrieved. I can tell you that that's not true either. All of these devices, they all have servers. And if you're getting into a serious enough situation and circumstance, police are going to go to the effort to get production orders, which is a type of search warrant. And they're going to get that information. So, the imaginative world in which something can actually be deleted, that's gone. I wouldn't count on that for anybody.
Now, great point again. And we're often going through that exercise of gathering evidence, one side or the other, doesn't matter, but putting it together, because sometimes it was a consensual relationship and now there's an allegation it wasn't, or vice versa. But either way, you've got to defend yourself. On that topic, or actually, Rob, we did have a question, so maybe we can bring that back up. So the question is, I want to come forward about something that happened to me at work, but I'm afraid my boss won't believe me. Should I talk to a lawyer? As I thought when I looked at it quickly, good segue to something else I wanted to ask you about, Ed, which is burden of proof, investigations, and credibility. Because a lot of these cases where there are allegations of harassment, there are no witnesses. People are not usually, I should focus on usually, not usually silly enough to do this in front of witnesses. And some people are savvy enough not to create that trail of text messages, Facebook messages, BBM, Snapchat, etc. So, this questioner, I have no idea what evidence there might be, but when you're dealing with a pure question of credibility, a he said, she said, as it's usually called, how do you advise either party, in terms of what's likely to happen?
Yeah, so that is very often the case in these kinds of circumstances where it is, as you say, a he said, she said scenario. And credibility in basically every case is going to be absolutely central. So, when a complainant comes to me and says, I'm worried about whether or not they're going to believe me, my commentary to that individual is, as we already discussed, well, what else do you have beyond your word? I'm not saying your word is wrong, but what else have you got? Let's put that together. So we gather all of that. Whatever we have, and whatever we don't, we work with and we deal with. Even if there's nothing there, that does not mean you're going to lose your case. And the flip side is I have to tell accused people all the time. They tell me, well, she's got no evidence or he's got no evidence. It's just that he said, she said. How could the police be taking her word over mine? Well, sometimes they will. And even with the burden of proof favoring you, as it does in a criminal case and a little bit different in a civil case, which I'll get to in a second, if a person is unshaken on cross-examination, they go through, whether it's the discovery process civilly or cross-examination in a criminal court, they are hammered with question after question, and they remember details. They sound honest and truthful. They can give you the kinds of surrounding circumstances, and the story has that ring of truth. It does make sense. They're not being tripped up by dates or by time or by other people and contradicted. You may have a problem. And so that's something that you've got to be aware of. Now, when it comes to the burden of proof issue, that's one of the primary issues that we raise when someone says, well, which way should I go, criminal or civil? In a criminal case, the Crown has to prove its case beyond a reasonable doubt. They've got to get up a very, very high hill to establish that. If you're suing, on the other hand, in civil court, the burden is now on you as the complainant, and the burden is proof on a balance of probabilities. So it's certainly easier. You're not going to send somebody to jail, but if your interest is a combination of shaming, monetary damages, getting a change in the workplace, those are the kinds of things you can accomplish against a much lower standard of proof in civil court.
Yeah, that's a great point. And one thing I always tell clients is that if you're going to go forward with a claim or defend a claim, no decision is made based upon truth, because the judge doesn't know what the truth is. They weren't there. Every decision is made based upon evidence, and whether it's on a burden of standard beyond a reasonable doubt or balance of probabilities, doesn't matter. You're going to have to prove your case or defend against the case being made against you. That's critical. And one of the things that our firm often does is we often coach our clients or investigators when they are investigating sexual harassment. And one thing to note is in Ontario, based upon Bill 132, which came into force about a year and a half ago now, when there is an allegation or even a suspicion of harassment, employers have a positive duty to investigate. And investigate does not mean prosecute. It doesn't mean prove that someone did something wrong so you can fire them. What it means is investigate to determine what actually happened. And one thing that I always tell investigators, an investigator might be a trained investigator or the per person in the HR department who got stuck doing this, right. They have to reach a conclusion. It's not good enough to say it's an issue of credibility, I can't decide. They have to decide one way or the other that they believe on a balance of probabilities. In other words, what is more likely than not, whether there was harassment or not. So that's critical for the investigator's perspective. One thing I wanted to come back to, though, is because we often have threats being made. And I've seen this happen where the individual will say, unless you pay me money, I am going to file criminal charges. And that's one thing that I always remembered from law school was my understanding, I'm sure you know this better than I do, is that it's unlawful essentially to make that threat in the course of civil negotiations. But I thought you could elaborate on that. And then I know we have another question coming in that we'll address after that.
Yeah, that's a big no-no, and but from my perspective, something that I love to see, because it's so often in a case where I'm defending somebody and they say, I've got this email or this text message or whatever it was, a Facebook Messenger, where someone says, if you don't do X, Y, or Z, here's what's going to happen. I'm going to ruin your life. I'm going to go to the cops. I'm going to go to work. I'm going to go to your boss. And that's a very strong indication that what's really going on here is you're being extorted. And that in and of itself, by the way, is a criminal offense. So you may completely turn the tables on the individual who thinks they've got you in a corner, but at the very least, you've now got a very strong piece of evidence that suggests this is about being vindictive. This is about something sort of different than just trying to get a valid claim, a valid truth heard in either civil or criminal court.
Yeah, I think that's a great point. And I see this often from employers. Employers will come in and they'll suspect that an employee is guilty of misconduct, whether it's harassment or theft or anything like that. And what they want to do is say to the individual, essentially, either you go away, we're not going to pay you a dime, and if you sue us, we're going to file criminal charges. And of course, this is a huge red flag that comes up. So people need to understand that there are two ways to prosecute these things, but you can't interchange them and use them to, as you said, extort money or extort a good result out of them by threatening criminal prosecution. So I know we had another question come in, and Rob, I was hoping you put that back up. If an employer is found to be innocent of false charges, I wonder if that's supposed to say employee. If an employer or employee is found to be innocent of false charges, what are the real-world recourse options? Great question. And I think, and Ed, I know you and I have talked about this, and one of the downsides of the Me Too movement is the sort of... Oh, thanks for clarifying that, Rob. Appreciate that. One of the things that we've talked about offline is, the loss of the presumption of innocence that the Me Too movement has generated. And I'm going to comment on that a bit later on in the show. But this is one of the real downsides, and it's always been a downside, even before Me Too. That if someone is accused of something horrific, such as, rape is an example, pedophilia is an example, workplace sexual harassment has now become an example. When someone is accused, if they defend themselves and are successful, that never brings things back to where they were before. They might be able to keep their job. They hopefully can maintain their marriage if they had one. But there are not a lot of options available to the individual. From a civil perspective, I'm often told, well, I want to file a countersuit. We're going to claim, for either for harassment or for malicious prosecution or that kind of thing. More often than not, there really isn't an option. As long as there was, a complaint was made in good faith. And that's something that I often have to explain to people. There's a very big difference between a complaint or an allegation that is made in good faith, but perhaps erroneously or unproven, and one that is made maliciously. If it's made maliciously, there may be avenues available, including defamation claims, etc. But more often than not, there is no option available or recourse available. That being said, if the employer rushes to judgment, and again, I'm going to talk about this in the last segment of our show today, when I get to talk for a bit of a longer period. If the employer rushes to judgment, then they may well be liable for damages, including punitive damages, bad faith damages, etc. So if the employer is guilty of not investigating fairly, they open themselves up to real liability. But Ed, from a criminal perspective, I'm not sure if this would even apply, but I'm not sure if you want to add to the question.
Yeah, I'm not sure how much I have to add other than to say it's a very uncomfortable conversation, because almost every conversation that I have with a client ends with, when I win, and we're always very optimistic and we go ahead and of course we always win. When I win, what happens? How do I go back and restore what I've lost? How do I get back my money? How do I get back my reputation? Well, that's not simple. In fact, that's a lot harder than winning the case, to be quite blunt. You will have spent thousands of dollars in legal fees. You will have, as you said, suffered potentially marital discord, employment loss, reputational loss, and subject to being able to prove, and now the burden's on you to prove that this was done maliciously, in bad faith, with no evidence, and it wasn't just the person overreacting or a situation where a judge says, well, the case wasn't proven beyond a reasonable doubt, because of course, while the standard of proof works to your benefit in terms of getting an acquittal, that means that when the judge finally does rule in your favor, he or she isn't saying, and now I anoint you innocent. They're just saying they didn't reach the burden of proof that they had to reach. It's a very high burden. So in most circumstances, you're out of luck, and you're throwing sort of bad money after good if you really start fixating on that. And so it becomes a very interesting strategic question that I think only lawyers with the kind of experience, both legally in the courtroom and outside of the courtroom, when you talk about media relations and PR, the kinds of things that I know you do, Stuart, and that I do, you can help in a different level, where you can say, look, there's a way we should be telling this story even before we get into court, because we need to be upfront and ahead of the curve when it comes to managing how that story comes out, particularly if your client is a person with some level of high profile. They're a CEO, they're an athlete, they're an actor, sports personality, the kind of thing that media is going to fixate on.
Yeah, that's a great point. And again, I'm going to come back to that in the next segment of the show, but I'm not surprised that we sort of flown through 25 minutes and easily could go for another couple of hours. But Ed, I really want to thank you for joining me and bring a completely different perspective to the discussion of the Me Too movement. And well, thanks again, and wish you all the best.
Hey, it was a pleasure being here. I look forward to the next case we do together.
Oh, I do as well. Thank you. Have a great day. And for anyone interested in learning more about Ed, you can go to crimlawcanada.ca or check him out on social media. Ed is extremely active and provides a lot of useful information for people. So he's easy to find and can provide you with a lot of great advice that won't cost you anything. All right, so now we get to do something new and fun. When we started this show, we called it Fire Away, and the idea was that you, the viewers, would have a chance to fire away at me and my guests, and we'd answer your questions. What we decided to do is add a special segment at the end where I get to fire away, and I get to talk about a topic of note and offer my comments on them. And as you can see from the background, Me Too is going to be the topic today. It's been the topic of the first 2 episodes, and while that's somewhat surprising in a way, it's not, because this permeates almost every aspect of life, as well as every aspect of the law. We talked about it in the family law context, the criminal law context, and of course the employment law context. But one of the things I want to talk about actually flows directly from what Ed and I just spoke about 2 minutes ago, which is this loss of presumption of innocence. And what happens if you are falsely accused and eventually you are exonerated, but where do you go from there? You often can't get your life back. You often can't get your job back, your marriage back, your reputation back. And this is one of the things that really troubles me about what has happened over the last half a year. We've seen a monumental change. We have gone from a situation where throughout modern history, sexual harassment in the workplace has existed, but was largely ignored, was tolerated, and those who complained were often either disbelieved, hushed up, or essentially, discarded by the organization. And it was very clear that the perpetrator was going to be protected by the employer, especially when the perpetrator was either the star or the rainmaker or the owner of the company. However, this has changed dramatically in the last couple of years, where organizations, at the hint of a scandal, are quickly basically discarding individuals. And we've seen this in Hollywood, high-profile CEOs, politicians, at least in Ontario. And my concern is that employers are going to take the lead from what we're seeing in the media, and as soon as they hear the word sexual harassment, they're going to fire the individual like that, without investigating, without giving them a chance to defend themselves. And if it turns out that there was a false allegation, they're not going to have any way at all to basically get their lives back. What's interesting to me is if you look at this historically, for decades, first of all, behavior that we would now consider to be completely inappropriate was essentially appropriate within the workplace. Look at shows like Mad Men, and they're not that far off from what we used to see in office space. And then even behavior that we knew then was unacceptable was still tolerated, and victims were threatened or forced out. And essentially, organizations looked at this as a cost of doing business. They would essentially say, we're not going to deal with it. We're not going to get rid of our star. He or she, well, usually he, is bringing in all the money. And if there's a complaint made, we'll deal with the fallout then. And I've written about this for years, saying, first of all, that we need to treat sexual harassment seriously, but also that employers are not going to take it seriously until it becomes more than a cost of doing business. They need to be willing to take action. The Ghomeshi scandal, which Ed and I talked about earlier, is a perfect example. You had literally a media star, and it was obviously a well-known secret that he would engage in sexual harassment. And as the report, which is conducted by a colleague of mine, Janice Rubin, as the report revealed, it was known, but it was never addressed, and he was allowed to continue harassing. He was essentially protected. And when the story came out, everyone was horrified, and they were aghast that the CBC would have let this happen. What was interesting to me is that when I would speak with people privately or in groups, almost everybody had their own story of the person in their organization who was known to be a harasser, who everyone knew. You never put the young female interns alone with so-and-so, and yet every organization allowed this to continue. The one positive thing that came out of the Ghomeshi scandal was that sexual harassment in the workplace became a real topic of discussion. And also, people became aware that they didn't have to tolerate being harassed, and employers became aware that they could not tolerate harassment in the workplace. We started to see, as I mentioned earlier, a lot more complaints of harassment being made. Unfortunately, the criminal trial had a bit of an effect of discouraging people from complaining, and it's unfortunate because that was really not exemplary of what will happen in a typical workplace investigation. But what is interesting is that when the Weinstein scandal broke in the fall, and we had the Me Too movement start, and Time's Up, etc., everything changed overnight. And now you didn't have organizations protecting the accused. You had organizations basically discarding the accused as quickly as they possibly could. And we now have a very popular hashtag, Believe the Victims, which I think is a great sentiment. And I want to be very clear. I've said this in writing. I'll say it now. I think it's great that employers and society as a whole are taking sexual harassment in the workplace seriously, and the perpetrators are being penalized. The problem with Believe the Victims is that what we're really talking about is believe the complainant. When we first hear of an allegation of harassment, we have two parties. We don't have a victim and a harasser. We have a complainant and an accused. And until you have evidence of the fact that there was harassment, you're dealing with someone who may be wrongfully accused. And I know that's not common. I know most allegations have some legitimate basis. But I will tell you from personal experience, I've seen it happen. I've seen it happen even before Weinstein, even before Ghomeshi. I saw a situation where 3 women working in a department had a male boss. The male boss retired. They all assumed that one of them would become the supervisor. And they were all extremely upset when an outsider was brought in to supervise them, a male outsider, I should say. And what happened? I got involved when they, as a collective whole, the 3 of them went to HR and said, our new supervisor is sexually harassing us, and gave examples of what he had done, touching, threats, etc. And my client wanted to fire the guy on the spot. And I said, no, you have to investigate. And this is one of the things that our firm does all the time. I don't care whether you're talking about harassment, theft, absenteeism, any kind of misconduct you suspect. I've written a book. It's called You're Fired. It's all about just cause for dismissal in Canada. And one of the prevailing themes is you never take action. You never discipline. You never fire someone without investigating so that you're satisfied that there is good reason. And what I often tell employers are usually reluctant. They don't want to incur the cost. They don't want to waste the time. They just want to move and send a strong message that we do not tolerate such conduct. And what I always tell the employers is you need to investigate. 1, because you need to be sure there was misconduct. Sometimes there wasn't. Sometimes it's a misunderstanding. Sometimes it's a false allegation. But also, if you investigate, part of that investigation has to include confronting the accused, giving them a chance to give their side of the story, and they may clarify what happened and help themselves. More often than not, though, they're actually going to help you as an employer, because what they will do is lie and try to cover up what they did. And now they've compounded their errors. They not only engaged in misconduct, they've demonstrated that they are dishonest and untrustworthy. And if you as an employer are going to go before a judge and say, we had just cause to fire this person, your case is going to be a lot stronger if you say, not only did they do X, Y, and Z, whatever the case may be, they were dishonest. We can't trust them. We cannot continue to employ them. And your case is going to be a lot stronger. But bringing this back to the sexual harassment Me Too movement, it's critical that someone who is accused of sexual harassment is given the chance to respond, given the chance to clear their name. Hopefully, I mean, we always see the ones that make the media. And at that point, it's usually too late to contain it. When we're talking about the average employer, the average employee, you want to contain this as much as you possibly can, maintain confidentiality as much as you possibly can, because if it turns out there was no harassment, you want to allow this person to resume as close to a normal life as they possibly can, as opposed to having had their career, their marriage, and their reputation decimated. So what I would like to say in closing is that the Me Too movement, in my view, is great. And I'm really happy that finally sexual harassment is not just seen as a cost of doing business. People are aware that harassment should not be tolerated, cannot be tolerated. But from an employer point of view, do not follow what you're seeing in the media and immediately dispose of someone who is accused of sexual harassment. Take the time, investigate properly, fairly, give the person the chance to respond, and then you make your decision. And I know it sounds self-serving, work with an employment lawyer. We can guide you through the process, whether you're investigating internally or externally. We can make sure it's done properly and also give you advice on how you should deal with it, depending upon the findings. And ultimately, you as the employer, and especially if you're in HR, you're the one who's going to be cross-examined if this goes to court. And you're going to have to justify the decisions that were made and the actions that were taken. So it's critical you do things properly. It's also the right thing to do to keep both sides and treat them both fairly. So that's my 2 cents worth. You got it here for free. And I appreciate the ability to fire away at the end of the show. I do want to wrap up by, first of all, thanking Ed Prutschi again for bringing a very interesting perspective to the whole Me Too movement. I want to thank all the viewers for tuning in. I want to remind everyone that past episodes are available online on our YouTube channel, Facebook page, on our website. Also to remind you of our next episode, which will be April 17th, again at 12:30. Next time, we're moving away from the Me Too movement. We're going to talk about reference checks, which can be of concern to all parties, what you can do, what you can't do, and how to do them properly without breaching your legal obligations, including privacy obligations. If you have any suggestions for other topics or guests, feel free to email us at info@rudnerlaw.ca or tweet to @rudnerlaw. And one thing I just want to end by reminding everyone is that at Rudner Law, we really do believe in education. Obviously, we enjoy doing things like this show. We have a blog, we have a newsletter, social media feeds. Feel free to take advantage of those. And I'll mention, Ed Prutschi as well. I mentioned it before. Huge on social media with a lot of good information as well. So check out his platforms. But please also remember, and I suspect Ed will agree with me, none of this replaces legal advice. If you suspect that you might need an employment lawyer, you probably do. Feel free to reach out to us. We'll be happy to talk to you, let you know if we can help. And if we can, that's great. If we can't, there's no harm done. But please don't try to avoid the legal costs by doing it yourself. That's all for today. Thanks for tuning in, and have a nice day.